The International Covenant on Civil and Political Rights, Article 2.2. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant, to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. We're looking at a judgment from R versus Hape, 2007, to see what the judge says concerning international law. Supreme Court Judgment of Canada, R versus Hape. The Constitution Act has brought forth the rights and freedoms guaranteed and expressed in the covenant, the international covenants, in accordance with the provisions of the covenant. It is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. The presumption of conformity is based on the rule of judicial policy that, as a matter of law, courts will strive to avoid constructions of domestic law pursuant to which the state would be in violation of its international obligations. We're looking at the International Covenant on Civil and Political Rights, Article 2.2. Now, this covenant is international law. It's part of the International Bill on Human Rights. And Canada is indeed a signatory to this covenant. And they have obligations and liabilities to this covenant. Now, in Article 2.2, it states that the rights and freedoms that are mentioned or brought forth in the covenant must be expressed, here's the obligation, they must be expressed in domestic law. So because Canada was a signatory to the covenant, now they had the obligation, the liability, to express the rights and freedoms that were in the covenant into domestic law. Now, more specifically in Article 2.2, it stated that you must express and ensure these rights within the Constitution Act of the country. In 1982, Canada created the new Constitution Act of Canada, the Charter of Rights and Freedoms. And this was to ensure or to give effect to the rights and freedoms that were in the covenant. By Canada taking these actions, they fulfilled their obligations to Article 2.2 of the International Covenant. If Canada would not have constructed or brought forth a new Constitution Act in 1982, then they wouldn't have followed the obligation that they had in Article 2.2 of the Covenant. But because Canada did indeed fulfill their obligation, that is why we have the new Constitution Act of Canada. Now, again, it wasn't just out of the blue that Canada decided to create a new Constitution Act. It was because international law bound them. International law produced the liability, the obligation, and Canada had to fulfill this obligation, and they did. The Constitution Act of Canada, 1982. Article 52. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. So we just saw how that international law controls domestic law. That's the first witness to this fact. Now, domestic law, Canadian law, it must conform to international law, to the rights and freedoms that are expressed internationally. It must. There's no ifs, ands, or buts about it. If domestic law is against international law, then international law overrules domestic law. Now, domestic law must conform or follow international law. That's the obligation. And as we saw in R versus Hape, that court judgment, the courts, they presume, they use the word presume, that domestic laws, the enactments, the regulations, follows international law, or follows the rights and freedoms that are established in the covenant. And the courts further state that if the enactments do not follow international law, then Canada is in breach of their obligation. What's interesting to note here in this judgment is it does not state that, the courts do not state that Canada does follow the international law. It says the courts presume. Now, to rebut that presumption, it's on the individual. it's up to me and you. If we find that there's an enactment, a regulation here in Canada that is breaching or removing our fundamental inalienable rights, then it's up to us to bring that before the courts and say, this domestic law is in breach of my international rights and it's not conforming to international law. Therefore, I'm not subjected to follow it. But the point being here is that even the courts know that domestic law in Canada should be following international law. So that's why when we come to the Constitution Act of Canada, Article 52, it states that the Constitution Act of Canada is the supreme law of Canada. Now we understand that the Constitution Act of Canada is expressing international law. We just saw in Article 2.2, it said the rights and freedoms expressed in the covenants must be expressed in the Constitution Act of Canada. And now we look at Article 52 of the Constitution Act of Canada, and it states that this Constitution Act is the supreme law of Canada. So there the link should show us that the international law is the supreme law of Canada, and it's just been placed into the Constitution Act of Canada. Now it further goes on to state in Article 52 that any law, any other domestic law, that is inconsistent or that goes against the Constitution Act of Canada is of no force or effect. And when we combine that with the judgment from R versus Hape, it says that they presume that domestic law conforms to international law, and if it doesn't conform, we have to rebut that presumption. And in the Constitution Act in Article 52, we see that operation of law taking place, where it states that the supreme law is the Constitution Act of Canada, and any other domestic law that doesn't conform to the Constitution is of no force or effect. So the operation of law has been preserved for us. Now, I contend, and Canada is very much aware of this fact, that within international law is where one man or one woman, human beings as plural, will find their natural, absolute, inalienable rights, their common law rights, being safeguarded and preserved in international law, such as the right not to be held in servitude, or for those who are more familiar with law, domestic law here in Canada, as the right to choice if you're going to be recognized or take designation as an artificial person before the law. There are many other rights and freedoms, natural rights and freedoms, that are expressed in international law that have been expressed in domestic law because of why? The obligation was there that rested upon Canada. It said, here's the right and freedom expressed in international law. Now you must bring this right and freedom into domestic law through the Constitution Act or other measures, but we're sticking right now with the Constitution Act. Now, the international covenants are twofold in nature. Some people think that it's just one fold, it only applies to a democratic society. It doesn't. It applies to one individual man or woman for their fundamental rights and freedoms, but it also applies to that artificial entity, to the one who's part of the democratic society. So the covenant, it grants rights and freedoms to the human being, and it grants rights and privileges or benefits to the artificial person. And the rights or benefits for the artificial person that is expressed in international law also must find its fulfillment, its expression within domestic law. So we're going to look at just one right now. The International Covenant on Civil and Political Rights. Every citizen, so you see the subject or player now is citizen, that artificial entity, the subject and servant of Her Majesty, the one who has taken an oath to Her Majesty and promised to obey the laws of Canada. Well, here in Article 25 in the International Covenant, it states every citizen shall have the right and opportunity, without any distinctions mentioned in Article 2, and without unreasonable restrictions, subsection B, to vote and be elected at genuine periodic elections. The Constitution Act of Canada, Article 3. Every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly, and to be qualified for membership therein. So every citizen of Canada has the right to vote. When we look into the International Covenant on Civil and Political Rights, we find the subject or player citizen in Article 25 of the Covenant. Now, this citizen is part of the democratic society. It is a citizen who is under allegiance to Her Majesty through the Canadian Citizenship Oath. I swear or affirm that I will be faithful and bearing true allegiance to Her Majesty Queen Elizabeth II, the Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada. There's the mechanism of binding your life. There's the mechanism of yoking your life to the rules and regulations of Canada. Nevertheless, the subject being brought forth here is citizen. And the citizen in the covenant is granted the right to vote. Okay, International Covenant says citizen, we grant you the right to vote. Now, we looked at Article 2.2 of the covenant that says the rights and freedoms mentioned in the covenant must be expressed or be given effect in domestic law. So there's the obligation. Citizen, right to vote. The obligation, you must express it in domestic law, Canada. Now, in the Constitution Act of Canada 1982, Article 3, we see it coming to bear. We see the citizen has been granted the right to vote. So again, we see the operation of law transpiring. International Covenant states the right or freedom. It must be expressed in domestic law, and then we find it expressed in domestic law through the Constitution Act of Canada. Now, this applies to the democratic society, to the artificial person, the subject and servant of Her Majesty. There are rights and freedoms that are recognized within the covenant, that are rights that apply only for the man or woman, only for the human being. And this artificial creation cannot exercise them, and the law is aware of this fact. And let us look at one of them. We're looking at a court judgment, SCC Thompson Newspaper Limited versus Canada, at page 1004. Everyone, referring to the Constitution Act of Canada, Article 7, everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. Another Supreme Court judgment, PBG Industries Canada Limited versus Canada, the Attorney General, 1982. An objection raised by the defendants, this is the Attorney General who was the defendant, in argument is that the plaintiff has no status to bring this action. The defendants argue that the beneficiary of rights guaranteed in Section 2, 7, 9, 10, 12, and 17 of the Charter is described as everyone. Notice that, as everyone. In those sections, the rights guaranteed are rights that only a human being can enjoy. The beneficiary of the guarantee in Section 8 is also described as everyone. Therefore, it is argued, since the word everyone must mean human beings only in the first group of sections, it must mean the same in Section 7 or 8, and thus the plaintiff would be excluded. So, as you can see, when you find the word everyone, the courts are aware that these rights and freedoms only attach to human beings. Everyone means only human beings. The International Covenant on Civil and Political Rights, it states in Article 8.2, no one shall be held in servitude. The Constitution Act of Canada, 1982, Article 7. Everyone, notice the subject, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. One of the natural fundamental rights that we have as individual human beings, as individual men and women, is that no one can place us into servitude. Now, there's a court judgment that says that the courts recognize that they can't allow Canada to do something indirectly that they couldn't do directly. In the International Covenant on Civil and Political Rights, Article 8.2, it states that no one shall be held in servitude. Now, we know that the citizen is under an oath of servitude already. Through the citizenship enactment, it is said that they have taken an oath, and in that oath they have placed themselves in servitude. When we look for the expression of this right, remember we saw the citizen has the right to vote, then we found the expression in domestic law, the citizen granted the right to vote. Well, here it says no one shall be held in servitude. And this has to be expressed in domestic law. When we look into the Constitution Act of Canada, Article 7, we find that it states everyone has the right to liberty. Now, liberty is the opposite of servitude. Not being in service, not being bound. Now, the player or the subject being spoken about here is strictly everyone. It didn't say the citizen has the right to liberty. Remember before we saw it was the citizen has the right to vote? Well, now it's not the citizen anymore, it's everyone. And as you've seen in the court judgments, Canada is aware, the legal system is aware, that every time you see the word everyone, that is only referring to a human being. And the rights and freedoms that are being mentioned or brought forth are only exercisable by a human being. So no artificial entity, whether it be a corporate artificial entity or another type of artificial entity, no artificial entity can exercise these rights. So as you see, no one can be held in servitude. That right, that freedom to exercise that right, attaches only to the human being. And it's clear because the citizen is already in servitude. Now, this is one expression of our natural, inalienable rights. Some would call it common law rights. This is an expression of it. And again, the courts and Canada are aware that we do exist on this territory as individual men and women, and we have inalienable rights, absolute rights, that cannot be removed from us. In my other videos, I've shared with you an enactment here in Canada called the Emergencies Enactment. And within it, it talks about if there's war or famine or a biological emergency, that the Governor in General, he has the power, the right to put special laws into implementation during this time of emergency. However, even doing such action, he must take regard or must respect the International Covenant on Civil and Political Rights. And then it states specifically more to the rights and freedoms that are never to be abridged and never to be limited. Well, one of those rights and freedoms that are never to be abridged or never to be limited, even during a time of emergency, are what you're seeing right here, Article 8.2. There's more than that, but this is one. So there's never a time in law that this state party can hold you in servitude, whether to the Queen or to an enactment. They're not supposed to have the ability. And if they do, then it's up to you to rebut that, to go against that. If the state party is trying to hold you to an enactment, that enactment is not applicable upon you as a human being. For whatever reason, the capacity, the designation that they see you under is that of the artificial person, that of the citizen. And that's why the operation of law to hold you to an enactment is being applied. Now, the courts have inherent jurisdiction. They have all the power necessary to produce or to administrate justice here in Canada. When you use the term administration of justice, what you are talking about is upholding or getting them to uphold your charter, your fundamental rights and freedoms that are in the charter. Every time you use the word administration of justice, that's the primary reason, the primary existence that the courts are present here in Canada, is to perform those duties. Now, if an enactment is placing you into servitude and violating your fundamental right, it's up to you to show all this to the court system and to ask for the remedy from the court system. In fact, there's a judgment, and I'll share it with you in one moment, that states that if you have trouble with the executive powers of Canada and you've communicated with them concerning your fundamental rights and freedoms, and they're still disrespecting your fundamental rights and freedoms, don't keep on writing them. Don't keep on pleading to them for them to respect your rights and freedoms. But turn now to the courts and enforce your rights and freedoms, because that is why the courts are present in Canada. And as you see, they recognize that we are human beings here on this territory, and that we have rights and freedoms that belong to us alone, that cannot be removed and cannot be attributed to an artificial person. And if this state party Canada or their officials want to disrespect, remove, bridge, or limit these rights and freedoms, then we have every available option or every right to stand up and go against them and say you do not have the power to do this because you are controlled by the rule of law. This is what law says. This is what you can and cannot do. So I have a right here and you can never remove it. And if you seek to remove it, then what you've done is you've broken the fundamental rule of law. And that the court will judge against. R versus Haynes, 1999. Listen to this. The determination whether to enforce constitutionally protected rights under Section 24 was never intended to revert to the executive arm of the government. Indeed, as has already been discussed, a primary purpose of the Charter was to place courts between the executive and the individual, to protect the latter's individual fundamental rights and freedoms. This is a judgment from the Supreme Court of Canada. Now, in Article 30 he wrote that the central concern of Section 24 of the Constitution Act of Canada 1982 would appear to be the maintenance and respect and confidence in the administration of justice, as that may be affected by the violation of constitutional rights and freedoms. According to Grant, the term administration of justice in Section 24 concerns maintaining the rule of law and its processes and includes upholding charter rights in the justice system as a whole. Again, a judgment from the Supreme Court of Canada. It states, it is important to note that the onus or responsibility is on the person bringing the challenge to demonstrate not only the restriction of the rights, but also that the state has not abided by the principles of fundamental justice. We're looking at the description of the nature of the courts here in Canada, and we find the following. A majority of this court described the powers at the core of the Superior Court's jurisdiction as compromising those powers which are essential to the administration of justice, which means upholding charter rights, and the maintenance of the rule of law, which define the court's essential character. So the court's essential character, primary reason, primary operation, is to uphold fundamental rights and freedoms through the administration of justice. When we look into the Supreme Court judgments here in Canada, we find that the court's main character has been described by the judges as the reason for being is to administrate justice. That's the essential or main reason for the courts, to uphold fundamental rights and freedoms. And that's considered the rule of law, to do such things. The rule of law. Now, we also further learned that it's you, the individual, that must show the violation against your right or freedom. The onus or the responsibility remains yours. Now, first of all, you can never show forth a violation of these rights and freedoms if you've never learned them, if you were never aware that they existed and Canada had the responsibility. How could you ever then walk into court and say, I've been violated? But if you come across the knowledge and understanding concerning the natural rights and freedoms that you have, the obligation that Canada had to fulfill them, and the lack of fulfillment that transpired on behalf of Canada's part, then you could go before a court. And it's the court's responsibility, its main essence of being, is to administrate justice, to uphold these fundamental rights and freedoms. And the court, it states that it is there against the executive powers. As you saw in that court judgment, don't keep applying to the executive powers. Don't keep complaining to the executive powers. It's up to you to invoke the inherent power of the court by showing the violation of the right and using the court system against the executive powers. And remember, earlier on in this video, it says the courts are presuming that all these domestic laws are upholding or are conforming to international law. So when you go in there and you say, no, this enactment, they're trying to hold me to an enactment that's against a fundamental right or freedom. For example, I have the right to decide if I will take recognition as an artificial being before the law, and this enactment only applies to artificial beings. Therefore, it's my decision. and they're refusing to allow me. The courts are there to uphold that fundamental right and freedom. Now when you further study, and that's not going to get more into this tonight, but when you further study the court systems here in Canada, when you're looking for which court to apply to, all the courts have the power and the ability to administrate justice, to uphold fundamental rights and freedoms. Yes, even a traffic court has the ability to uphold fundamental rights and freedoms. It all depends on your approach to the court and how you bring yourself into the court. You will further learn through studying the justice system that inherent jurisdiction, the right to go and seek the administration of justice, is not something that's granted automatically to the parties. When the lawyer comes in from the opposite party, if he's representing the Crown or another individual, when that lawyer comes in, he's not seeking to administrate justice. He's not seeking to uphold fundamental rights and freedoms. He's using the rules of the courts, he's using enactments and regulations to play the game within court. So when the courts say that inherent jurisdiction or the power of the court to administrate justice is not automatic, it's not. The lawyer's in there, he's not seeking this, the judge's not going to afford it to him. You come into the court, if you don't come into the court in the proper way, the judge is not going to afford the inherent jurisdiction to you neither. There's a process that must be used. When you look again in the Constitution Act of Canada, Article 24, it states anyone whose rights and freedoms have been violated, as that have been granted by this charter, can seek compensation in a proper jurisdiction, in a proper court of law. But then they don't give you any procedure to follow. They just simply make the statement. Well, when you further study the justice system, you see that it states, we are aware of the fact that in Article 24, individuals have been granted the right to seek remedy if their fundamental right and freedom has not been fulfilled. But there's no specific process that's going to be created in order for that individual to seek their justice. We, the court systems, are going to fit these applications in to our present court structure. What we're going to do is, we're going to say that all courts here in Canada, the main character of that court is to administrate justice and to uphold fundamental rights and freedoms, international law and that were transferred into domestic law. That's the primary reason for the court to be there. Now, when you go in there, if you approach the court in the capacity in that way, then you put the court in the situation to have to use their inherent jurisdiction. If you don't, they will not invoke it on their own. That's up to you. That's why we further see if the enactment goes against you. In Article 52 of the Constitution Act of Canada, it says if the enactment is against the Constitution, it's of no force or effect. The courts say we presume that the enactments follow international law. The courts say then you must show the violation against your fundamental right and freedom. The courts further say that we're here for you if there is a violation that the executive powers are doing. And the courts further say that our number one reason or main reason is to administrate justice, is to uphold your fundamental rights and freedoms. But all this is at the end of the line. All this is once you understand that, oh, I have natural rights, and they've been recognized in international law. After the Second World War, men came together and they said, we have to recognize rights and freedoms of individual human beings, because if not, governments grab too much power and place their people into slavery. Look at what's happened with Hitler and that government. And they drew up these covenants, and they included or recognized our natural rights. These natural rights, these absolute rights, these inalienable rights, they were not created by the covenants. They've been in existence with mankind as far back as we can remember. They were just expressed and recognized, and the legal obligation or liability was placed upon any state party that would sign upon these covenants. And when Canada became a signatory, they became obligated to allow us to exercise these rights and freedoms. And when we study more about the laws of Canada, we see that in some ways, yes, they have provided measures for us, but in other ways they have failed. They have not fulfilled their obligations. And it's up to me as an individual to say, I'm going to exercise my fundamental rights and freedoms, and Canada, you have that obligation.